All right, so today we're planning to talk about what the role of the Supreme Court is. And so the US Constitution is composed of a preamble, 7 articles, and 27 amendments. And today we're going to talk a little bit about the interplay of the first 3 articles. So Article 1 establishes the legislative branch. It kind of outlines its powers, the composition, and some of its limitations. Article 2 establishes the executive branch of the president, detailing powers, duties, and election process a bit. And Article 3 establishes the judicial branch, which is the Supreme Court and lower federal courts, and outlines its powers and the role of the judiciary. And so today Ken's going to talk us through some of how the Supreme Court and presidential power interplays a bit. So first of all, Ken, how are you doing today?
I'm doing very well. I'm glad we're going to get a chance to talk about this. What I think is interesting is that we really have been seeing a lot of discussion about what President Trump and the agencies have been doing. There's been some discussion about what the courts have been doing, but we really have not seen the Supreme Court in action yet. In relationship to a lot of the activities that have been going on. And so what we're going to be doing today is trying to maybe do a little bit of a prediction of at least what's going to be on the table coming up between the executive branch and the Supreme Court.
This is great. So if maybe just to start off, could you tell us a little bit about what are the ways that the Supreme Court affects the presidency?
So there really are 2 main ways that the Supreme Court is going to be interacting with the executive branch and the presidency in this context. One is the constitutional aspects of the president's powers and the authority of the agencies. So these are going to be examinations of what are the president's inherent powers, what are his powers in relationship to the agencies that are below him, and how are these all part of the constitutional structures that were created by the founding fathers. The second half of the Supreme Court's authority regarding the executive branch has to do with statutory authorities. That means that at some point the Congress has in the past delegated some of its legislative authority to the president or to the agencies, essentially saying to the president of the agencies, here, we're giving you the authority to exercise some kind of power. We're giving the authority to the Department of Agriculture to give money to farmers. We're giving the authority to the Department of Justice to exercise criminal law regulation or enforcement. So these are 2 very separate authorities that the Supreme Court has. Today, I'd like to focus principally on the constitutional authority, because that is a slightly more discrete aspect of what's going to be going on in the future, and B, because constitutional authorities, constitutional decisions that the Supreme Court makes tend to be more permanent. The ability to amend the Constitution is very, very limited. And so once the Supreme Court has spoken on a constitutional decision regarding the executive branch, then that's probably something we're going to be dealing with going very far into the future.
That's great, Ken. And I think in your response, I'm hearing at least like 2 future episodes that we might need to think through, which are like, what are those statutory authorities, and kind of can the legislative branch give a lot more than they've given in the past to like kind of strengthen up the executive branch. So I'm curious about that later on. We don't have to answer that today. And also, I know this question about amending the Constitution has come up in a lot of circles and in the media as well. And so I think there's a future conversation about that too. So appreciate you putting pins in those. In terms of constitutional interpretation and the Supreme Court, tell us, like, why is this important legally, politically?
So constitutional interpretation is interesting. The Supreme Court isn't going to necessarily be identifying everything they do within the context of constitutional interpretation. Sometimes it is kind of a post hoc discussion by scholars of how the Supreme Court is doing their analysis. Sometimes the Supreme Court justices will kind of get out front, give speeches, and will describe the different ways in which they are interpreting the Constitution. The reason that this is legally very important and significant is that the Constitution really is a very diverse document. At one level, it has some things in it that does not require a lot of interpretation. For instance, a person cannot be president until they have reached the age of 35. Not a lot of interpretation necessary there. On the other hand, states may not violate a person's due process. What does that mean? Well, it turns out that can mean a lot of different things. And in fact, it means many different things in many different contexts. A person cannot the Congress may not violate somebody's equal protection. Well, what does equal protection mean? Does equal protection apply to racial classes? Does it apply to socioeconomic classes? Does it apply to immigration status? These are very, very ambiguous terms, very flexible terms, and terms that are certainly not textually obvious. And so interpretation is very, very important. And how you do that interpretation is, again, something that is just, it's really a game-changing kind of discussion that goes on and really has to be, kind of decided as to how Congress is going to make this kind of decision. Now, why is this politically important? Well, it's politically important because the Supreme Court really has to uphold their reputation. These are Supreme Court justices with life tenure, and there is a certain amount of trepidation that the Supreme Court is going to take in making major decisions. And there is going to be a need for the Supreme Court to justify their decisions as not being made for the whims of the Supreme Court or being made because of some kind of political underpinnings, but that these opinions are being made for reasons that are consistent with the purpose of the Constitution, that are consistent with the founding fathers, that are consistent with the reasons of the document. And this becomes particularly important when the Supreme Court overturns cases. And we'll be discussing a little more the one of the most prominent theories of constitutional interpretation, which is originalism. Originalism is a theory that really only arose in the 1980s and principally arose in opposition to a number of cases that were considered to be by more conservative justices to be relatively activist cases such as Roe versus Wade, cases regarding sexual privacy, cases regarding contraception. The idea that finding those rights in the Constitution was not a representation of something that the founding fathers would have originally decided were protected by the Constitution. And so originalist theory was put out essentially as an argument for why those cases should be overturned. And so as a constitutional theory, it might have to have borne an additional burden that not only was it going to be a constitutional theory that would need some explaining, but it also have to be a constitutional theory that would justify overturning precedent. Following precedent is actually one of the major constitutional interpretive theories, which is the idea that is really the basis of almost all Supreme Court case law, which is that you start with the assumption that everything that's been decided before by the Supreme Court is in fact good law, and you're just kind of deciding the law going forward. And you'll really see this when people get in front of the Supreme Court to argue. They tend not to argue starting from scratch. They tend to argue everything the Supreme Court has said right up to the most recent case. And their suggestion to the Supreme Court is almost always, look, you already decided this issue, that we're just asking you to go just a little bit further. You've got all this precedent. That is really generally considered a very, very strong legal argument. And so the judicial precedent theory of constitutional interpretation is really generally the theory of interpretation that justices want to hear. Theories like originalism are much more disruptive and really are used much more in the context of we want you to overturn cases that you have heard previously. And so again, these are really they're both constitutional interpretation theories, but they really carry different burdens.
Yeah. And so if I'm like hearing this correctly, interpretation is important because there's ambiguity in the text, there's implied powers, and then there's also these like reasons for maintaining the reputation of the court. And there's different kind of philosophies around interpreting the Constitution. And you named two of them, one being originalism, where we're going back to the time of the founding fathers and trying to get in their heads and thinking about what did they intend at the time of ratification of the Constitution, which is an interesting philosophy to take, considering kind of everything else that was happening in the country at the time. And then there is judicial precedent, right, which is relying on previous decisions of the court. And are when folks use one of these philosophies, are they completely parallel? Like, do people switch between different philosophies? I know in other contexts you've mentioned other ways of interpreting the Constitution. When we're talking about these ways of interpreting the Constitution, are justices following one path and that's their philosophy across the board, or do they kind of pick and choose based on what's in front of them?
That's a great question. Again, this is all a little bit post hoc, meaning that a lot of times it's kind of going backwards and seeing what justices have done and then trying to describe it. I think that you can probably almost put this into a best practices scenario and then a real world scenario. So, best practices, I think the best way that the justices could address how you deal with constitutional interpretation would be really what I would consider a cascading use of legal theories. And I'll just run through a number of different legal theories and the best way that they could be used. So, one legal theory is called textualism. Now, textualism is one of those inherently, it sounds like a great idea until you think about it for 5 minutes. Textualism is obviously just the idea that it says it in the text. If it doesn't say it in the text, then why are we talking about it? Well, that makes perfect sense until you get to the very beginning of all judicial cases, which is the theory of judicial review, which is the idea that the Supreme Court gets to tell Congress that, no, you just crossed the constitutional line and we're striking that down. Judicial review is not in the text of the Constitution. There's nothing in the Constitution that says the Supreme Court is allowed to strike down congressional law. That is essentially it's an implied power. It was decided very early on in the case of Marbury versus Madison. Everybody's very comfortable with it right now, but it's one of many, many incredibly basic ideas that are not in the text of the Constitution. All of the Bill of Rights as applied against the states, that's not in the text of the Constitution. That was happened after the Civil War, and they are all incorporated through the Bill of Rights, actually through the Due Process Clause, which is a long history that we won't get into. Those are those both big ones. I'll give you some silly ones. We have a space force. There's nothing in the Constitution about having a space force. The Constitution mentions having an army. It mentions having a navy. Nothing in there about a space force. Does that mean we can't have a space force? No, of course not. Here's another one. We're allowed to have coined money. There's nothing in the Constitution about having money, currency, paper. And they actually, they knew what paper was at the time. As a matter of fact, they didn't like paper. Rhode Island had issued a bunch of paper currency and they'd gone into bankruptcy. They did not like currency. And so they essentially left it out. They said, no, we like money. We like hard money. So textualism is it just doesn't work. It works for 5 seconds and then it falls apart immediately. So textualism, good place to start. You look to see, does it say anything about, what you want the answer to? That's a great place to start, but it's a very beginning port. Then go to precedent. Is there any precedent? If not, then we move to originalism. And originalism sometimes is a good place to look. If you've really got no precedent, then hey, let's look what the founding father says. That's not a real problem. Sometimes originalism doesn't really get you any place. The Fourth Amendment, for instance, what if you're using a heat-seeking device to look inside a house to see whether somebody's growing marijuana plants? Originalism doesn't help. There's no such thing as a heat-seeking thermometer, a device this background, the founding fathers. So, what else can you move to? Well, there are other things like historical practice. That doesn't apply here. There's pragmatism, there's moral reasoning. A lot of times, what you end up doing is actually logic, analogy, kind of essentially common sense, which is pragmatism. And so, what really makes sense is that in most cases, is you just take, you take an ambiguous language and you try to make sense of it within with using legal reasoning within a real context of the real world. And the real bottom line is that the founding fathers were not a bunch of academicians. They were not a bunch of scholars sitting around. My apologies to Ivy League law professors, but they were not professors who were sitting around kind of coming up with these abstract ideas with kind of extreme answers. They were politicians, and they basically were trying to come up with a working, living document. And these are just many different ways that the Constitution can be interpreted. And for most purposes, this all works out fine. But the problem is that there have been there's political tensions that have now been entered into the Supreme Court process, where some of the common sense, some of the pragmatism, some of the agreement is breaking down, and is breaking down in ways similar to the way things are breaking down in our broader political system, in the same way things are breaking down in our broader society, where we used to have a value of common mores, a value of stability over change. And now it seems like a lot of that is breaking down, and it really is almost up to the American people to start signaling whether or not they want to return to the values of stabilization over the values of change, which is what's really going on right now.
Yeah. When you were talking about currency, I had a question about, what does the Constitution say about crypto? I mean, there's I'm kidding.
Not a
Um,
lot.
right, not a lot. So you walked through kind of this best practice of kind of cascading through the different ways um, interpretation can take place. Is that usually how this plays out? Our cascading best practice? Like, is this best practice cascade used?
So, what's really interesting about the Supreme Court is that most cases that the Supreme Court is deciding are cases that actually never reach the front cover of the New York Times. You never read about you wouldn't hear about them on Fox. You might not even read about them on, your local blog page. They are statutory, or if they're constitutional, they're really very narrow. There really are only a handful of cases per term, which are the ones that we consider kind of the big hot button cases. Those are the cases where the cascading interpretation that I'm talking about probably start breaking down. And this is probably not that new. I think that we can look towards we can look in the past. We can look at the movement of cases in many different courts. So, for instance, the New Deal court actually represented a fairly sharp departure from the court that was in place right before the Depression. So
Yeah.
FDR was facing a court that was looking very skeptically at the expansion of federal power. There was right after he made proposals to expand the number of Supreme Court justices, in which case he would be able to appoint a number of justices who might have a broader view of the federal power. Fairly soon thereafter, the Supreme Court started taking a more expansive view of federal powers, and we actually live today in a much broader regulatory power context than existed before the New Deal. The Warren Court was known for expanding individual rights in a fairly significant way. Cases that were not, or rights that were not existed before that. The Rehnquist Court was known for maybe not being particularly, they were limiting on federalism. They came up with limits on federalism. To some extent, they were maybe trimming the sails rather than significantly overturning existing case law, but they certainly were signaling that there were limits to the expansion of federal powers, and which was actually part of what was going on in the federal government and in politics generally. And now the current 6-3 court, and to some extent even before the current 6-3 court, even back to the 5-4 Roberts court. I'm kind of roughly articulating what the conservative to liberal split has been recently. We've been seeing more cases overturned, the Dobbs case overturning Roe versus Wade, the implementation of originalism to overturn cases that were seen as having been going further than necessary. And to some extent, we're even seeing perhaps some judicial activism on the court, where if you didn't like textualism in the context of liberal liberal ideas being imported into the Constitution. Now we're seeing things that are not textually in the Constitution, but are being found in the Constitution by the 6-3 majority. Things like immunity for the president, things that are like state sovereignty, equal state sovereignty for states is a concept that was recently found to exist when the Voting Rights Act, Section 5 of the Voting Rights Act, was struck down in Shelby County versus Holder. The idea was that the southern states are being treated differently from the northern states for purposes of reviewing their voting practices. And so this new idea that, again, you don't find it in the text of the Constitution, which was equal sovereignty of the states, was found to exist. And so I would say that we're now even seeing some activism by the court. And where is this coming from? Not even sure I would put it in originalism. Can you find it in some other constitutional theory? You could probably find a home for each of these more activist cases. Historical practice has become maybe a substitute for originalism in the theory of, well, we haven't seen it before. There's a case called Prins that said you can't commandeer state officials. And again, there's nothing in the Constitution that says you can't do that. But the historical practice argument that was made by the conservative justices is, well, we haven't seen that before. We don't see that in the early history of the country, and so it must not be constitutional. Or the Second Amendment, we have the Bruin case that says, well, there were no concealed carry regulations in the early history of the country, and so we don't see concealed carry as being a valid gun regulation under the Second Amendment right. So there are homes under constitutional theories for some of these rights, but so it's just interesting. I would say that maybe it depends which. It's not clear that which of these theories are eventually owned by conservatives or liberals, but certainly it does seem at this point that the judicial activism, which used to be an accusation against the more liberal justices, is now an accusation that I think can be leveled against some of the more conservative justices.
That's super helpful. And yeah, I was just wondering what you kind of answered at the end. So, you went through the different Supreme Courts using the Chief Justice's name as like the Warren Court, the Roberts Court. How important is it to the Chief Justice that they have like a consistent theory that they're applying, or, reputationally or politically, in terms of what they're trying to achieve? Because that becomes the legacy of the court, which you're kind of showing.
I think chief justices have been very interesting in that way, that more so than other justices, I think chief justices seem to look towards the integrity of the court, look towards the consistency of the court. I think Chief Justice Roberts in particular seems quite interested in the legacy of the court. He did recently come out and specifically issue a statement regarding the idea that the executive branch and the presidents need to comply with court orders, which is a bit of a statement, essentially out of the judicial, um, uh, normal, the normal thing that a justice would say, kind of wandering into politics, but he felt it was important to say.
All right, that's great. And so I think bringing it back to the Supreme Court and what's in front of them, kind of what their interplay with this executive branch could be. Are there some cases that you're watching regarding the executive branch with the Supreme Court?
So this is very interesting. So I think the 6-3, more conservative court was being looked to over the last year or so as potentially being faced with a number of cases that would lead to them considering overturning, cases that would be more, I don't know, more classically associated with the originalism cases. And so, for instance, cases like Obergefell, same-sex marriage, cases such as Griswold, contraceptive, those were the cases that people were kind of talking about, a little more worried about. I'm not sure anybody was concerned about the executive power cases that might be coming up in front of the Supreme Court now. The cases that are coming up through the district courts now are both a little more fundamental and a little less within what I would consider to be the, I want to say, the Federalist Society kind of judicial conservatism that's been a little more traditional. These go more to,
Ken, um, do you mind saying what the Federalist Society is?
yeah, I'm sorry. So the Federalist Society is a group of conservative law students, lawyers, judges, justices who have annual meetings or generally are associated with a legal conservatism that, as I said, are probably more closely associated with things like originalism and legal conservatism. They're not necessarily conservative in the same manner as political conservatism. It's not necessarily social conservatism or behavior conservatism, but it's more conservatism of how governments should be structured and who should be making decisions, and perhaps a little bit more about economic conservatism. So it's a slightly different wing of the Republican Party, but and for that reason, I think it is usually associated with things such as what will the courts be doing, what will they be deciding, and less having to do with kind of substantive policy issues. So having said that, the kinds of cases I think the Supreme Court could be hearing very soon are cases nobody was really thinking about. So let me give you an example. Humphrey's Executor versus the United States, that is a 1935 case that deals with the idea of independent agencies. Now, there are two types of agencies in the executive branch. There are cabinet agencies, which are the big agencies we mostly think about: Health and Human Services, Department of Education, Department of Labor. These are agencies where the agency officials are appointed by the president, confirmed by the Senate, and the cabinet agency officials are fired at will by the president. He can fire them easily. There's over 100 independent agencies. Most of these agencies don't have cabinet agency officials. What they have commissions. So, for instance, the Security and Exchange Commission has a series of commissioners. Their job is to essentially develop regulations, to oversee the securities industry, to develop how cases will proceed against, for instance, securities fraud, against insider trading. It's very specialized. It involves a lot of expertise. And the commissioners tend to be, for independent agencies, they tend to be mixed between appointments by Democrats, or the appointments have to be Democrats, Republican appointees. They tend to be staggered terms, and they tend to be terms that are not directly associated with a presidential term. The idea being is that these agencies are not politicized. They're supposed to be stable and extending over presidential terms, and so that they do not change rapidly, and that they're essentially there to provide continuous stability over a particular regulated industry. So, and this is very significant in a lot of contexts. Federal Trade Commission is one of those. Equal Employment Opportunity Commission is another one. There are many agencies that operate with a certain amount of distance from the presidency, and consequently, they operate with less political oversight. So, President Trump has fired a number of these commissioners. He's fired 2 Democratic commissioners of the Equal Employment Opportunity Commission. He fired the head of the NLRB. He's fired a number of other independent agency commissioners, which in theory he doesn't have the authority to. You can fire independent agency commissioners for cause, meaning things like malfeasance or misconduct, but not just because you want to fire them. And so these cases will ultimately, they're being litigated, and there will certainly be arguments based on the fact that the statute doesn't allow him to fire them, but there could well be arguments that Humphrey's executor should be overturned. So that's one significant case. Independent agencies. Another one is Cleveland Board of Education versus Loudermill. That has to do with whether federal employees have due process rights that keeps them from being fired. Another one is whether agencies can just decide not to spend money that Congress has said that they have to spend. That is Train versus City of New York, and that those are 3 good examples of very big, significant executive branch cases that could well go before the Supreme Court.
Is there active litigation on these? Are there current cases that are kind of in the pipeline?
There are current cases. The current cases are going to mostly be dealing with statutory limitations. All 3 of those cases are going to have statutes that are the first decisions that are going to, those are the first issues that are going to be litigated, because there are the Civil Service Reform Act prevents firing of federal employees. And so where those federal employees how they have to be fired, et cetera. That'll probably be the first issue litigated. There's a statute that says you can't not spend money. It's called impounding money. That's the Impound Control Act. So there will be statutory issues, but behind all of this will probably ultimately constitutional issues too. So, yes, there's ongoing litigation. It's just getting going. It could take a long time before it gets to the Supreme Court, but we don't know. Sometimes the Supreme Court's been taking this stuff a little quicker than not.
That's right. So I know we had a lot to cover here today. And so today, you talked a little bit about the role of the Supreme Court regarding presidential power, different types of constitutional interpretation, why it's important, how it's used, a little bit of a best practice cascade that can be used, and some of the kind of limitations of different types of interpretation. Is there anything that you want, and as well as the court cases that we should be looking out for that will really impact how we view executive power and how executive power is used? I'm wondering if there's anything we didn't get to cover that you were hoping to cover today.
Nothing in particular. I guess I would just sometimes advise people to, if there is a particular court case that is of particular interest, it is worth digging in and reading the merit cases. Sometimes you don't necessarily want to look at all parts of the case, but sometimes it is worth digging in and actually figuring out what is at issue with some of these cases. It's worth understanding the historical basis for what's going on. These are interesting issues that are, there's a lot of reasons for the executive branch being in the state it is today. For instance, the reason we have the Civil Service Reform Act is because the history of how the executive branch was operated in the past, and some of the corruption and some of the difficulties, and really to recognize that there was a lot of hard work putting into developing our modern regulatory society. And even though there may be some flaws in it, there were definitely some reasons why it exists as it is today, and it's really worth knowing the history of what has gone on in the past and where we are today. So I'd encourage people to kind of dig in and learn the specifics when you can.
Do you have a resource that you would recommend for folks to do that digging in?
I'd start with Wikipedia. It's a great resource. Sometimes it's the best place to start. Is a lot of times the editors of those pages are actually some of the better some of the real people out there who actually have been working on these issues. So it's a great place to start.
That's great. Thanks so much, Ken. It was great to chat with you today.
Okay, thank you, Sadhna.